Alden v. Maine case is the day that the music died. The day the music died. So the 1890 Hans decision fucked over all Americans. Basically all Americans in federal courts. No American can sue a state and federal court, says the 1890 Hans decision. Then the 1999 Alden v. Maine decision comes out and it says no Americans can sue a state government even in state courts. So talk about an overfucking reach. Jesus Christ, they're going against Americans. You know, we don't have rights in federal courts. We don't even have rights in state courts. Alden v. Maine is, maybe this is the backbone to the, you know, the whole sovereign immunity, you know, the whole sovereign movement. So Alden v. Maine, you're sovereign, you think you're above the law? This is some bullshit. The 11th Amendment is interpreted to deny even more rights than what its strict construction actually dictates. The state courts decided in the 1999 Alden decision that they wanted sovereign immunity, and therefore they denied citizens even from using their own state courts to sue their state governments. Jesus Christ, this is a disgusting and disturbing trend. A terrible decision, a Dred Scott decision, Plessy versus Ferguson, Schenck decision, Chaplinsky. This is terrible. This is awful. Alden v. Maine. Who did we protect in Alden v. Maine? So it ended it for everybody. Everybody, basically after 1999 Alden v. Maine, I don't even know how you can, you know, go around pretending that you're a freedom-loving American. You had 4 dissenters, so it's a 5-4 split decision, so fantastic. You're going to base your thing on another split decision, Seminole Tribe, split decision, Alden v. Maine, split decision. Atlantic Kagan, I swear. So Justice Souter, Stevens, Ginsburg, and Breyer all dissented from this case. Souter wrote the dissent. So Souter wrote the dissent, Stevens, Ginsburg, and Breyer all dissented. So 5-4, Alden v. Maine. I want to focus on Souter's dissent on this case. He also dissented in the Seminole case, too. So Souter dissented in the Seminole case. Souter dissented. SOUTER, S-O-U-T-E-R, whoever, Souter. And he also dissented in this 1999 Alden v. Maine case. This dog shit crappy case. Okay, so what is he saying? Souter said a lot of stuff, okay? So, you know, buckle up. 11th Amendment is expanded beyond what the federal government allowed. Sovereign immunity was a background principle to the 11th Amendment, but sovereign immunity itself isn't law. It's not held up by the Constitution. Nowhere in the Constitution does it say this. This is Justice Souter. To the Seminole Tribe dissenters, of whom I was one, the court's enhancement of the 11th Amendment was at odds with constitutional history and at war with the conception of divided sovereignty. That is the essence of American federalism. So sovereign immunity isn't mentioned in the Constitution. Immunity might not even be mentioned. The crown, the royal king and queen, they may insist on immunity because the king can do no wrong, right? Yeah, I'm sure. The emperor wears no clothes. Beautiful, you know, clothes, but none. Never a federalist government. The federalist government divided into 3 branches, you know, I mean, what would that even look like? 3 branches, they all have immunity from each other or just from the people? Natural law says basically, you know, it's a universally applicable proposition discoverable by reason. This is his definition. Souter's definition of natural law is a universally applicable proposition discovered by reason. So a law that's basically by reason, you just can, we have a right to sue. So Jesus Christ, Hamilton, Federalist 81-82 may defend sovereign immunity, but there's no consensus at all amongst the founders about the principle of sovereign immunity. This is chief, you know, they're Justice Souter. Some are for it, some are against it, some are for mixed results, but ultimately the people of America are the sovereign. For the purposes of the Union, you can't have states that are sovereigns. I mean, for federalism, for the purposes of the Union, for 3 branches, Jesus Christ, states aren't sovereigns. The people are the sovereigns in a democracy, and the sovereigns, we do have subjects, and those subjects is the government. In a democracy, the people are the sovereign, and the government must abide and listen to the people. The subjects of a democracy is the government. John Jay said that when one state sues another state, that all the people of that state sues all the people of the other state. Chief Justice John Marshall, a.k.a. Little John, in America, the powers of sovereignty are divided between the government of the Union and those of the states. They each are sovereign with respect to the objects committed to it, and neither is sovereign with respect to the objects committed to the other. So they're sovereign in some respects, sovereign in that. This is John Marshall, Chief Justice, Little John. And this is out of McCulloch v. Maryland, 1819 Supreme Court case in the McCulloch decision. This is a great quote. I'll repeat it because I like the quote so much. In America, powers of sovereignty are divided between the government of the Union and those of the states. They are each sovereign with respect to the objects committed to it, and neither are sovereign with respect to the objects committed to the other. Okay? That, clear as mud. Essentially, they're sovereign in their own respective domains, but they're not totally sovereign at all. This is, Chief Justice John Marshall, John Jay, who cares about what they're saying? Yeah, fuck you. I care. Blackstone, the king is superior to you in every way, right? That's the whole idea of the sovereign immunity. Bow down so the king can, kiss his ass. It makes it so much easier for him to complete the business of governing the people if you just kiss his fucking ass and do as he says. You lowly maggot scumbag, plebeian, pedestrian, peasant you. Sovereign immunity is an obsolete royal prerogative incompatible with the democratic Republican tradition, history, principles of democratic republicanism. The king used to be above the law. We hated that. That's why we overthrew the fucking king. If a person should have just a just demand upon the king, he must petition him into his court of chancery, where his chancellor will administer right as a matter of grace. They're not upon compulsion. They had courts, but you weren't going to force the king to listen to you. He'll just, as a matter of grace, maybe give you some justice. Fuck that shit. That whole sovereign immunity. The American Revolution was fought for taxation without representation, for being taxed by a government power, but not being represented in the halls of that government power. There's no sovereign immunity when we have a right to a revolution. We have a right to a revolution. That's Colorado, Kentucky Constitution, plus American we are the birth of our country. We were born in revolution. How can you say we don't have a right to a revolution? Sovereign immunity. Get the fuck out of here. 1776 Americans would be absolutely embarrassed of the 2020 Americans that would allow this shit show parade to carry on. Or 1999, right? Alden v. Hayes? No, Alden v. Maine. 1999, Alden v. Maine. So what are we going to say about Alden v. Maine? Okay, this is the SOUTER's dissent. SOUTER's is, kicking ass and taking names. He says, the strong possibility that federal courts can mediate lawsuits. They're non-biased third parties, right? They can do this between the various states and the citizens just as the Constitution says that they should. They're non-biased, disinterested third parties. That should make the federal courts jump at the chance. They're supposed to jealously guard their power. They can actually be a judge on a case of which it needs a judge. A judge is needed, but there's no judge found. The federal judges, the federal courts can resolve the disputes between the peoples and the states. It would be absolutely perfect. But ultimately, how fair are federal courts? They're kind of telling on themselves with the, Alden v. Maine case, 1999, Alden v. Maine case and the Allen v. Cooper case, 2020. They're telling on themselves. They're saying if you're an individual, the sovereign immunity of the state just trumps any fucking thing. You what? Copyright? Fuck you. Maybe give me something about commerce. If you can come up with a commerce clause, explanation of how you got injured, then you could sue the state possibly, but that's the only way. So they're fucking, they're burning their own ass. That shows you that the court system is not for the people whatsoever. They don't want regular folks in it. It's an elitist class. You have to get into their club, win the bar or whatever. So to defend oneself against the Espionage Act, just for example, for Julian Assange, if he gets extradited to America, he's going to need $1 to $3 million worth of legal fees. Chelsea Manning needed $1 to $3 million worth of legal fees. $1 to $3 million is how much you need to defend yourself in a federal fucking court. Nobody goes to the federal court to get their, differences resolved. And why would you expect justice in a federal court? I don't know anybody that uses a federal court. The feds can do whatever the fuck they want to do. They stack the deck. Look at how they, did that impeachment trial. It's politics. And the judge, if they like you, maybe you'll get justice. If he doesn't like you, well, then fuck you. You don't get no goddamn fucking justice, you poor plebeian, low-life peasants, you. So what common person uses federal or state or even county courts to resolve their differences? Basically, you just got to figure out how to get along on your own. You can't expect these goddamn fuckers to help you, achieve justice. So this is, just to say 3 times, so that way, 1999 Alden v. Maine, 1999 Alden v. Maine, 1999 Alden v. Maine. And what they found was that Alden was an asshole, and Maine, well, they were a bunch of pieces of shit. And so Alden and Maine both got fucked out. I don't know exactly the decision of it, but this is they defended sovereign immunity, and SOUTER in the dissent in Alden v. Maine is saying, fuck your sovereign immunity. Take your sovereign immunity and shove it up your fucking ass, you fucking Scalia fuckers. Was it, or Hamilton, Alexander Hamilton, loving Massachusetts, Connecticut, Rhode Island, Georgia, they had charters, colonial charters. They specifically said that the corporate body of Massachusetts, Connecticut, Rhode Island, and Georgia can be sued. So the Constitution of these states are incongruous with their interpretation. The American Revolution, right? So the strong possibility for Alden v. Maine, the federal governments can, so many court cases they could actually resolve if they gave a shit about justice or the people who are actually the sovereign. It's not the economy. The economy, is treated as the sovereign, but it's the people. The people are the sovereign in a democracy, especially in America. So the holding for the 1999 Alden v. Maine case is that the Constitution bars an individual suit against the state to enforce a federal statute under the Fair Labor Standards Act of 1938 when brought in the state's courts over its objection. So shit. Even in state courts. If the state court says we don't want to hear this shit because we got sovereign immunity, then no American, you can't go to the federal courts, you can't go to the state courts. The feds took, the sovereign immunity another step way too fucking far. So SOUTER dissented rightly. He said sovereign immunity was essentially killed with the American Revolution. When we got the Constitutional Convention, when we passed the Articles of Confederation, the Declaration of Independence, that's when we killed sovereign immunity. Sovereign immunity was murdered by the American Revolution. When we kicked the sovereign out, when we said King George III, fuck you, you think you're sovereign, you think you're above everybody, you piece of shit. We don't want no sovereign motherfuckers in this goddamn country. So the 1999 Alden decision felt a terrible decision, almost as bad as the Allen v. Cooper decision. They're both very shitty. They're Dred Scott decision. 1999 Alden v. Maine is a Dred Scott decision. Plessy versus Ferguson, terrible decision. Citizens of Maine, they get to sue the state of Maine, right? For the Fair Labor Standards Act of FDR? No, they don't have rights. The Congress, they can't pass these laws. You're going to just... I guess they got judicial review, right? Stare decisis precedent. Judicial review. Yeah, well, supremacy clause, motherfucker, necessary and proper. This shit's necessary and proper, and they're supreme. So, McCulloch v. Maryland, federal government wins in McCulloch v. Maryland. I think that Ogden v. Gibbons is a federal government victory, too. So, Ogden v. Gibbons, the federal government wins in commerce, and then in McCulloch v. Maryland, the federal government, when they want to institute a state bank in the state of Maryland, you can't object to it. You can't sit there and, try to tax them out of existence. No. So that's SOUTER's dissent in Alden v. Maine. So the 1999 Alden v. Maine is when the music died, but the dissent in Dred Scott, the dissent in Dred Scott decision, Abraham Lincoln is going to read the dissent in the Dred Scott decision, and basically say, okay, Supreme Court, you got to listen to the law, but you don't have to agree with it. The Republican Party forms around the idea that the Dred Scott decision is bullshit, and then Abraham Lincoln becomes president, Civil War happens, slavery is abolished. So the end result, Dred Scott decision was supposed to say slavery is the law of the land forever and ever. America is slavery. But ultimately, because it was such a dumb, stupid, backwards-ass, shitty decision, and a war and amendments and all this other shit happened afterwards, it said slavery is bullshit. So the Supreme Court, I guess that's a function, right? The Supreme Court could get a decision so fucking wrong. They could be so far off the rocker that it just spurs the American people to, rebel and fight for a brand new, different world. No, we don't want to be a part of the world where this Supreme Court makes these stupid-ass 1890 Hans decisions, Schenck, Chaplinsky decisions, Plessy versus Ferguson in 1999, Alden v. Maine kind of decisions, the 2020 Allen v. Cooper decisions. You know, they could say their decision, and that's the law of the land, but we got democracy, and we could change shit. So we could pack the courts. Well, no. There's some other things we could do, right? So, yeah, Alden v. Maine, 1999. Terrible split decision, just like the Seminole Tribe split decision. SOUTER is going to dissent in both of these cases, and his dissent essentially is, what the fuck are you assholes? Sovereign immunity? What the fuck are you assholes talking about? There's no sovereign immunity in America. There's no crying in baseball. In America, you can't cry in baseball. So that's the 1999 Alden v. Maine decision. Peace!